Okay, good morning. So today I'm going to talk about protecting assets for those you love and when should estate planning begin. So when should estate planning begin? Well, it should begin now because, how many people are affected by illness or incapacity? We saw that with COVID, people were sick, not expecting to get sick, ending up in the hospital for long periods of time. And if they don't have a power of attorney in place, no one can manage their affairs while they're in the hospital. And if they don't have a healthcare proxy, if they became incapacitated, there's no one designated to make healthcare decisions. So, that kind of is a point of why we should think about estate planning now rather than later. So what's the likelihood something will happen to you or your loved ones? Well, it's pretty likely someone at some point could get sick or have an accident. You want to think about who can make decisions for you. You want to plan ahead of time so that you can designate those individuals you trust and you would want to make your decisions. And you want to be able to maintain control where you can in creating your estate plan. So when we're creating an estate plan and you're going to meet with an attorney, what are the things that you want to think about? Well, you want to think about, are you healthy and independent? If you're married, are you both healthy and independent? Or is one of you sick or has poor health? Has your spouse passed away? And you would have other people you want to protect when you create your plan. So how do we begin? Well, you're going to think about who are your loved ones. Are you married? And if you're married, is this your first marriage or do you have children from a prior marriage? Do any of your loved ones have special needs? Do you need to think about protecting them receiving benefits? Do you have any minor children or grandchildren? Any disabled beneficiaries or elderly beneficiaries? Do you have any pets that you want to plan for? Protect them. Are there any charitable organizations that you want to support? You're also going to think about your assets. What are your assets? Well, do you own property? Is it in New York? Do you have property out of state elsewhere? You snowbird? Do you have any bank accounts or investment accounts? Retirement accounts? Do you have life insurance? Or do you own a business or professional practice? You also want to think about what are your goals with creating an estate plan? Do you want to protect your assets for your own benefit or the benefit of your spouse? Do you want to preserve assets for a particular purpose or leave assets to future generations? Do you want to make a legacy gift? And will your estate be taxable? You want to think about who you can trust to carry out your wishes. You want to designate individuals you know are going to act in accordance with your wishes and will be capable of carrying out your wishes. You want to think about for what period will my estate or trust continue? And will anyone contest my wishes in my estate plan? So what are the first steps to estate planning? Well, they're what are called advanced planning tools. And this is something anyone 18 or over really should have in place, because once you're 18, under the law, you're considered an adult, and it is a power of attorney, a healthcare proxy, and a living will. So a power of attorney is a document that enables one to appoint an agent for decisions affecting money and property. And why that's important, especially for someone 18 and over, is if something happens to that individual and they become incapacitated and they have accounts and assets in their name, there's no one designated to administer those assets unless you go to court and petition for a guardianship. An example of this is we had a client, a young woman in her 40s, had an asthma attack and became incapacitated. She didn't have a power of attorney in place or any estate planning documents. Her family, having to deal with the unexpected extreme health issue, also had to now petition to the court to become her guardian, to be able to administer her assets, and And now they have to account to the court every year, and the court is involved in this child's life. If the young woman would have had a power of attorney in place, it could have avoided that. A healthcare proxy, that's a document that designates a medical decision maker. And that's where you can designate an individual to make decisions if you become incapacitated. The doctors are always going to listen to you first if you can speak for yourself. This is in the event that you are unable. And this is also important for anyone over 18, because if you have a child going away to college and something happens, the doctors aren't going to speak to you. We had a client whose child was in college. They ended up hurt and in the hospital. And the parent went down and tried to discharge the child, and the doctors would not allow her to, because she was not the healthcare proxy. The child was over 18 and could make decisions for herself. So the mother was stuck, had to come back till the child decided that she would be discharged and come home with mom. So it's very important. We recommend anybody 18 or over have this in place, and parents should make sure their children sign that before they go away to school. Another important advanced planning tool is a living will. And that's the document that contains specific instructions concerning end of life and healthcare choices and treatments. And why this is important is if you're out of New York State, or if your healthcare agent is unavailable, it expresses your wishes. So another important tool is a last will and testament. So why is this so important? Well, it's the only way to designate guardians for minor children. So if someone has a minor child and does not have a last will and testament in place and does not designate someone to care for their child, if something happens to those parents, then the family is stuck having to petition to the court for guardianship. The person who ends up caring for your children may not necessarily be the individual that you want to raise and care for your child. So it's important for young parents to think about creating a last will and testament so that they can decide who will care for their children if, God forbid, something happens to them. A will effectuates the transfer after death of property titled in the name of a decedent. So, any assets held in your name alone when you pass, your will is going to designate where they go. But it's effective only after death. So the will, nothing can be done with a last will and testament until after you pass away, and it must first be probated in a court to take effect. So that can be time consuming, and there's court involvement. Also, the surrogate's court record is public. So, there's lack of privacy. A will is also important because it can express how you want your assets to go once you pass. If you don't have it in place, there is a statute that says how your estate goes. So if you die without a will, New York law states how your assets to go. And, we had a client, unfortunately, that was a gentleman. His wife died, and he had a longtime girlfriend, and he had children from his prior marriage. He procrastinated creating a last will and testament. And, one of the things was his children really didn't bother with him, and he wanted to leave his assets to his longtime girlfriend. He procrastinated and unfortunately got sick and ended up passing away without a will. Well, the law would provide that his children would be entitled, did provide that his children were entitled to his assets, and his longtime girlfriend lost out because she had no legal rights. They weren't married, and he hadn't created a will to designate how he wanted his assets to go. So it's very important to have a will in place or something in place to establish how you want your estate to go, because if you don't, it will go in accordance with the law, and that may not necessarily be who you want to receive your assets. So I talked about a will has to be probated. What is probate? Well, it's the legal process that's required to prove the validity of a will. You have to submit the will to court to prove it's valid. It settles the affairs of the decedent's estate. and it resolves claims of creditors to the estate. It allows you to adjudicate the interests of heirs and other parties, and gives the executor, who is named in the will, the authority to transfer or retitle property or other assets in accordance with the last will and testament. Another important document that you can create as part of an estate plan is a trust. And what a trust is a legal arrangement in which a person or organization controls money and property for the benefit of another. So you can establish a trust and designate someone to control the assets in there for the benefit of your beneficiaries. It starts with a written agreement between the creator of the trust, who's called the grantor, and the manager of the trust, who's called the trustee. And it's set up for the benefit of one or more beneficiaries. Once the trust is established, the grantor delivers the assets to the trustee to hold and use for the benefit of the beneficiaries. And the trust agreement specifies the rules. It's the plan of how the trust is going to be administered. So what are the advantages to using trust in estate planning? Well, there's lifetime advantages because a trust is created during your lifetime and takes effect once it's signed and funded. The grantor or the creator maintains control and directs the manner in which assets are to be used, invested, or managed. So you as the creator can designate how the trust is to be administered. It's an effective tool for unification of accounts and assets. You can put all your assets into one pot, into the trust, and they'll be administered in accordance with its terms. It provides a succession plan for successor trustees and successor beneficiaries. So your trust can designate if your initial trustee can't act, there is someone else who steps up in line. And it also can provide for beneficiaries and then future beneficiaries of the trust. It can provide specific protection for minor or disabled beneficiaries or others with special needs, so that it can protect the assets for their benefits, but also if they're receiving governmental benefits or if they're too young to actually receive them outright, it gives the authority of somebody to administer it on their behalf and still allow them to receive benefits and to receive the assets at a certain age. So what are some post-death advantages of a trust? Well, like a will, it effectuates the distribution after death of the property titled in it. But this allows for ease of administration. It's less costly and less time consuming. A trust doesn't have to be probated, so you don't have to go to the court. Once you pass away, it still can be administered as it was during lifetime. You don't have to get court permission or have anyone designated to administer the trust. It also avoids what's called ancillary probate for properties in other states. What that means is that if you own property in New York and you own a house in Florida, well, then you have to do 2 probate proceedings if they're titled in your name alone. You'd have to probate in New York and also probate in Florida. If you put these assets in the trust, it avoids that process and they would be administered in accordance with the terms of the trust. No probate is needed in New York or Florida. And the assets are immediately accessible to successor trustees. So, again, there's no authority that has to be received from the court to administer this. They can just administer in accordance with the terms of the trust. And it maintains privacy because it's not probated, it's not public record, it's not sent to the court. So what are some other considerations when you're creating an estate plan? Well, you're going to want to think about assets that do not pass through your estate or pass directly through beneficiary designations. For example, if you have an IRA, 401k, those generally have a beneficiary designation that is going to usually be an individual, not your estate. Life insurance policies, those also have beneficiary designations. Assets that are paid directly to another person on their death, on your death, excuse me. The example of this is a payable on death bank account, or assets that are held in joint names. If you own with a joint owner, when you pass it automatically becomes their asset. You also, if you want to make gifts or charitable donations, there's different ways to do that. It can be done through a last will and testament, through a trust, You can do it through beneficiary designations, through an IRA account, 401k, 403b, through bank accounts or insurance. You can make gifts of specific dollar amounts or fractional shares of an estate or an account. And the gifts can be contingent, after a first beneficiary. If they're not around, you can leave that to a charity. For example, if you left it to your spouse passed away, you can leave your assets to a charity after that. So what if you have a loved one you want to protect that has special needs? Well, there's special provisions we can include in documents called a supplemental needs trust. And what it is incorporated to provide for the supplemental needs of a person with a disability or beneficiary. The intent of these trusts is to supplement but not reduce governmental benefits which they may be receiving or becoming entitled to. So what it does is it creates a trust with funds or assets to be used for the disabled beneficiary's benefit, but it protects them so that it doesn't affect their ability to continue to receive governmental benefits. It's important if you have a spouse that is on Medicaid or may eventually be receiving Medicaid, you have a disabled child who's getting SSI, SSD. These are different tools that we can use to protect assets to be used for that individual's benefit, but also not affecting their ability to still receive their governmental benefits. So what if we don't plan? Well, it's always good to start early. Emergency planning may not accomplish your goals and reduces the ability to preserve assets. We see this a lot, unfortunately. Sometimes people didn't plan ahead for Medicaid, do any kind of Medicaid planning, and it becomes an emergency situation. Someone now needs Medicaid. There are still strategies that we can use to preserve and protect some assets and make them eligible. However, if they had planned earlier, we could have preserved more, and they would have been able to designate better how they wanted these assets to be protected and how they wanted them to go once they pass. If you don't plan, also, there's no one available to manage your assets during a lifetime or make healthcare decisions. If you don't designate a power of attorney, if something happens to you and you have assets in your name alone, there's no one able to manage them. Your family now would have to go to the court and petition for a guardianship to be appointed as guardian to be able to manage your assets. And that is time consuming, expensive, and there's court involvement. And also with a healthcare proxy, if you don't have someone able to make healthcare decisions on your behalf, the doctors may not talk to you, to the person that you want. There is a statute that designates the way that they will speak to someone to be a healthcare decision maker, but it may not necessarily be the person that you would want or would act in accordance with your wishes. And, again, in regard to the healthcare proxy as well, a loved one may have to bring a guardianship proceeding to petition to be your guardian to be able to make healthcare decisions on your behalf. And it's costly, stressful, time consuming. They're already dealing with your ill health, and now they have to deal with a court proceeding, and there's court involvement and accounting to the court during the ward's entire lifetime. So if someone has to petition to be a guardian for a family member, now they're responsible to account to the court yearly for the entire lifetime of the person they are the guardian of. Also, if you don't plan, your estate may not be distributed as you wanted. You may want to cut somebody out or put somebody in that if you didn't create a will may not be entitled to any of your assets in accordance with law. So you want to make sure you set up a plan so that you can designate beneficiaries of your choosing. If you don't have a will and you have minor children, now your family must petition to the court for custody of your minor children. And if it may not necessarily be the relative or the family member or loved one that you would want to raise your child. So, it's important for young parents to set this up and designate an individual that they would want to care for their child. And it places a burden on loved ones. It's much easier on your family member and loved ones. They're dealing with the loss of you, that if you have a plan in place, they just have to administer it. They know your wishes. It's done in accordance with your wishes. They don't have to worry, or the court doesn't have to tell them this is how it has to be. And it takes the burden off of them, you know, when they're dealing with the death of a loved one. It gives them a little bit of ease in the process. So when's the time to plan? Well, you should plan now. Everyone over 18 should have a healthcare proxy, power of attorney, and living will. You should create an estate plan when you're young, you know, new parents, just married, young families, and update it at different stages of your life and as you accumulate assets. So, you know, you may want to start when you're first married and you have children. Then you want to look at it, you know, midlife, when your children maybe are a little older of age, and then again when you're planning for retirement. You know, you should continuously review your estate plan, and we recommend it be reviewed every 3 to 5 years to make sure everything is in accordance with your wishes, that your beneficiaries are what you want, that your fiduciaries are who would want to be responsible, and who you designate, and you didn't, you know, because things change. You have different relationships with people over the years. Children grow up, you have grandchildren, you retire, your assets accumulate. And, you know, it's always good to look at your estate plan every 3 to 5 years. Your estate plan should be created with the assistance of an attorney who concentrates in estate planning and elder law. This is to ensure that documents meet the legal requirements and that they comply with your wishes. You know, there are those services out there, LegalZoom, or you can find things online, but you don't know how many times we see individuals coming in thinking they had a good and valid will or good and valid power of attorney or healthcare proxy, and they created it themselves, and it just did not accomplish their goals, and it wasn't legally appropriate, or it didn't include provisions that were necessary to do what we needed them for. So it's always important to reach out to somebody who concentrates in these areas to help you set up your estate plan. And, you know, emergency planning is not ideal and may not accomplish your goals. It's much easier to plan ahead when you're healthy and you can sit down and talk to your attorney and think about it and determine how you want your plan to go, rather than somebody is ill, somebody is sick, we have to do it in emergency. It's not going to necessarily accomplish all the goals that you would have wanted if you had done it, you know, when you were healthier and had time to think about it. And it alleviates the burden on loved ones, and alleviates court involvement, because if you have an estate plan set up, your plan tells your loved ones how to administer it, and it designates the individuals that you want to care for you or help make decisions for you. If you don't do that, then whoever can petition to the court, and, you know, the court can then decide on that petition who is going to make decisions on your behalf in regard to finances and health decisions, and even minor children. It may not be who you want. So, you know, if anything, you should think about planning sooner rather than later, and every 3 to 5 years, look at your plan, make sure it's still up to date and in accordance with your wishes. Okay, I have some. All right, so I have a question in the chat. I recently had a gay couple buy a home. They are married. Does the fact that they are the same sex change everything? Nope, because they're legally married. They're considered a spouse under the law. So you know, it recognizes them as a spouse. It wouldn't be any different of any married couple. Is a living will different than a DNR? Yes, a living will is different than a DNR. A DNR is something you create in the hospital. It's a medical document. That's regard to if you want to be resuscitated. A living will is, and that's something that you create with a medical professional. An attorney would create a living will that expresses your decisions in regard to end of life. For example, if you wanted a feeding tube, you wanted pain medication, you wanted surgery in certain instances, or someone to, you know, care if you're in an uncurable state, whether they just provide you with pain medication or you want them to do everything they can to keep you alive. A DNR is just in regard to whether if you have a heart attack or stop breathing, whether to resuscitate you. So that's something you create with a medical professional. A living will is something you would create with an attorney. So I had a question that was sent in. My spouse and I have moved from New York to a different state. We did an estate plan in New York with a living will, healthcare proxy, power of attorney, and a trust. Are they still valid? Your documents, yes, they're valid. So as long as the documents you create are valid in the state they're created, they're a valid document. Now, some states have different signing requirements for, you know, powers of attorney or healthcare proxy in which they're notarized. Ours are notarized. But if you move out of New York into another state, you don't necessarily need to update your estate plan. Your documents would be valid. If you are thinking about redoing your estate plan, at that time, you may want to update them. But as long as they're valid in the state they're signed, they are valid in other states. I had someone ask me, I read that in one instance where a power of attorney was insufficient to provide protection for relatives of a patient in a nursing home to pull their relative out in order to transfer them to a nursing home. The nursing home refused to allow the person to be transferred. What is the solution for this rare event? So what probably happened in that case was, you know, you wanted that the documents they had, whether at a healthcare proxy or power of attorney, didn't provide authority for an individual to move them from one facility to another. You know, it needs, that's why it's important when you're creating an estate plan that you do so with a professional, an estate planning attorney who is aware of the language that needs to be included. You know, our documents, our healthcare proxies include provisions that allows the agent to make decisions about what nursing facility to move individuals from one to another and to have the authority to do that. You know, the facilities are only going to work, they want to protect themselves, so they're only going to work in accordance with the terms of the document. So if it didn't have the language in place in either of their documents to be able to move them, they wouldn't have the authority. The remedy for this, unfortunately, is someone's going to have to petition to court for guardianship to be able to make decisions to move this individual from one facility to another. So that's, again, another reason it's very important to have, you know, documents such as healthcare proxies, powers of attorney in place. Does anyone else have any questions? You can unmute yourself or type it in the chat.
Hi.
Hi.
I just attended a week or so back a lecture from an attorney in Massachusetts, and they claimed that the power of attorney there, if it was processed in New York State, would not be valid in Massachusetts. Apparently, there's maybe a difference in the number of signatures that's required. On the other hand, you're stating that generally speaking, the documents in one state are carry over to other states. So I want to try to clarify that.
Well, look, generally, yes. I mean, in New York, other documents we look at if they're valid in the state they're signed. Now, like I said, some of them have different signing requirements. Maybe we have 2 signatures and a notary in New York. If it's not valid in Massachusetts, you know, I don't know every other state's law. If, you know, if it's a concern, you can always check with an attorney in that state. But I know, you know, for Florida, I believe they're valid and some of the others. So, but a will shouldn't be an issue at all. The powers of attorney sometimes have different signing requirements. They must need more than 2 signatures because ours require 2 witnesses and a notary. Anyone else have questions?
One area that you didn't elaborate on was the difference between a revocable and an irrevocable trust. I'm not sure you can go over that in the next 20 minutes or not.
Sure. I mean, I can do a brief overview. So The difference between a revocable and irrevocable trust is a revocable trust is where you as the grantor can still remain the trustee. You can administer all the assets in the trust. You know, you can change the trust whenever you want. You have the ability to touch everything in the trust. The reason a revocable trust is important and helpful in estate planning is it's a tool that can be used to avoid probate. So you can establish, you know, you can establish a revocable trust, the Jackson Revocable Trust, put your assets in there, and then when you pass, it avoids probate. You don't have to probate your will. But what it doesn't protect, the reason we do irrevocable trust is for Medicaid planning a lot of the time. So an irrevocable trust is a trust where you can be the creator, but you generally designate another individual as a trustee because the assets in an irrevocable trust are insulated. You're not allowed as the grantor and beneficiary to touch the principal. You would only receive income from that trust. And the reason we create those a lot of the time is to do for Medicaid planning, because when Medicaid looks at this trust, as long as there's different time limits, for nursing home care, there's a 5-year look back for Medicaid. So when you put the assets in the trust, you know, a house, an investment account, something that you don't need the principal of, that you can live off the interest, or it's a large asset like a house, it starts the clock running for Medicaid. And the asset is insulated, and it's not something that Medicaid can look at when they're determining if you are eligible, because for Medicaid purposes, there's very minimal resources you're allowed to have, which is $15,900. So when we use these irrevocable trusts, it starts, once you put the assets in there, it starts that clock running. Now for nursing home care, it's 5 years. So again, that's why we always recommend it's important to plan earlier rather than later, because if you plan now, you're healthy for 5 years, you put your big assets in the trust, they're protected. Medicaid can't look at them, they're in there, you've met your 5-year period. If you come to the point where you don't plan and it's an emergency situation, you may not be able to protect those assets, you know, because you didn't plan ahead. But the reason they're allowed is because you as the grantor can't touch the principal. It's an income only trust. And for home care Medicaid, we're kind of in a limbo period, but they're going to start looking at 30 months. Their look back's going to be 30 months. And currently, the law was supposed to change in October, but because of COVID, it's in a limbo period. So the old rule was 3 months back. So if you're thinking about doing Medicaid planning sooner rather than later, you can right now get in under the old rules, but generally it's going to be 30 months for home care and 5 years for nursing home care. So, but the irrevocable trust, the same as a revocable, avoids probate. It's a tool to use in estate planning. Your trust can be administered when you die. Nothing has to be probated. The difference is how the assets in the trust can be touched, because if in a revocable, you can be the grantor and the trustee. You can touch the assets, change the trust, but it's not insulated for Medicaid purposes. An irrevocable is you designate a trustee to administer it. You can receive income, but you can't touch the principal. But they're both avoid probate. They both are good tools to use depending on your purposes.
Kristi, if I could ask, I guess I'm not clear with the DNR as opposed to living will healthcare proxy, because we had a friend whose dad passed away, had a heart attack at the house, and he really wasn't in good shape. He had just, back and forth to the hospitals, 95 years old. Mm-hmm. And the family did not want, and he did not want to be resuscitated at that point. Mm-hmm. And the ambulance that arrived said, my friend gave me the whole gory details. We have to, because there is no DNR. And my friend was saying, but he's got a healthcare proxy and he's got a living will and all of that stuff, and that didn't help. What do you do?
They ultimately have the responsibility to save lives.
Oh, yeah,
So,
no, I understand. If you
yeah.
call an ambulance.
I don't know. Did they have the healthcare proxy living will on them at the time? Or you don't know?
I don't know. I know that my wife was actually speaking to one of the ambulance techs, because she's a doctor, and they were trying to help. And the guy said, look, we were called here because he had a home health care aide who called.
Mhm.
And he said, we don't come to bystand, we
Right.
come to save lives.
Right,
So,
unless, and fortunately or unfortunately, I mean, that's their goal, is to, if they're called, they're going to protect a life. If you had the DNR in front of you, they would have to, they would have to comply, but they're going to also protect themselves from any liability. So they're gonna,
well, the extension of that is that he was taken to Winthrop, and they were still trying to revive him. And Winthrop would not honor a healthcare proxy or the living will at that point, and said, no, you need it as a DNR, and he doesn't have a DNR on file here. So,
was he able to speak for himself?
no.
They should have probably listened to the healthcare proxy. I mean, a DNR there, but again, I don't know what you could do. The hospital, unfortunately, their ultimate goal is to preserve life. If the healthcare proxy was there saying, I guess it would also depend, I'm not a medical professional, so what process they were in of the reviving, I don't know if you can just like stop mid process. I know with the DNR, if somebody becomes coding or whatever, then if they have the DNR, then they don't have to try, but maybe because they were already in the process of trying, they couldn't stop. I mean, they should.
I don't know. It was a hard issue.
Yeah.
And they kept on using the defibrillator and compressions. My wife does not have hospital privileges at this point in her career, so she wasn't, and she's a gynecologist, which doesn't help us too much here. But it was a tough situation, and and trying to follow that up. I haven't seen Larry since this occurred to say, hey, do you guys do a DNR? That's why my question.
Yeah.
And I guess not.
No, that's something you would do with a medical provider. But the healthcare proxy, the living will, really the healthcare proxy is most important for New York, but if you can't speak for yourself, they're supposed to listen to your healthcare proxy in accordance with your wishes. I don't know, the situation when they were there, if the healthcare proxy was there, or if there's a legal requirement for medical professionals. If they've started to resuscitate someone now, they can't stop. I don't. But the DNR would be the document you do with the medical provider that says, do not resuscitate me in the event that I'm having a heart attack, or my heart stops, I become unconscious.
Okay.
I don't know what kind of repercussions, if they didn't listen, there would be.
I don't know. I was, watching from afar, and it was, well, not too afar, but it was kind of disconcerting. But
yeah,
I don't know.
Someone just asked, does a hospital have its own DNR, or is a general one which applies to all? I believe there is a New York State form. Each hospital may have their own. If you're thinking of signing one, I would recommend you do it with, if you're going in the hospital, make sure they have it on file. Your general practitioner has it on file, because if you just sign one and nobody knows about it, if it's needed, it may not be available. So you should.
Leah, Kristi, I could add to that we were told that there's a New York State through the health department. It's called the MOLST form, MOLST.
Mm-hmm.
And that is, it stands for something.
Yeah, I think I forget what the MOLST is different. And I apologize because I haven't looked at
That's what my wife was told that the patient needed to have, as a MOLST, MOLST.
Right. And that I haven't looked at in a while, so I don't remember the language, if it's the same as the DNR, if it's different. But if that's something that you have to do, that's not something an attorney can do. It has to be done with the medical provider, and it should be on file with your medical provider if that is something you feel strongly about signing.
Okay.
And it should be available, I guess there should be a copy or the available or the original at your home in the event that something like this happened, where there is an emergency paramedics come to the house so that they can present it. But thank you very much for attending. And if you need our assistance, please feel free to reach out, and, you know, I'd be happy to meet with anyone, you know, to help answer your state questions and set up a plan.